A defining moment. The Supreme Court's verdict on judicial eligibility. The Indian judiciary witnessed a significant development on Tuesday, May 20, 2025. The Supreme Court of India delivered a crucial ruling. Candidates must now possess a minimum of 3 years of active legal practice. This decision reshapes the entry criteria into the subordinate judiciary. The landmark judgment was rendered by a distinguished bench. It comprised Chief Justice B.R. Gavai, Justice A.G. Masih, and Justice K. Vinod Chandran. Their collective wisdom culminated in this case. The decision impacts countless law graduates and high courts. It aims to ensure future judges are well versed in practical realities. Tracing the roots, the genesis and justification of the experience mandate. The requirement for prior legal practice is not an entirely new concept in India. Its origins can be traced back to initiatives taken by certain high courts. Notably, the Madhya Pradesh High Court introduced such a rule. This was done through an amendment to its judicial service rules way back in 2002. This early move set a precedent. It highlighted a growing recognition of the value of practical experience. The rationale then, as now, was straightforward. It aimed to ensure that individuals appointed as judges possessed a foundational understanding of courtroom proceedings and legal practice. The primary justification for this 3-year rule is deeply rooted in pragmatism. The judiciary believes that essential courtroom experience is critical. It equips aspiring judges with practical legal skills. These skills are often not fully developed through academic learning alone. Voices of accord support for a seasoned judiciary. The Supreme Court's decision to mandate 3 years of practice has found strong endorsement from key legal bodies. The Bar Council of India, the apex regulatory body for lawyers, has been a vocal proponent. Various state bar councils have also echoed this sentiment. Their support stems from a shared belief. They believe that practical experience at the bar is an invaluable asset for a judge. It is argued that such experience provides a unique perspective. This perspective cannot be replicated by academic achievements alone, however brilliant they might be. This support lends considerable weight to the ruling. These legal bodies emphasize that experience gained in the heat of trial advocacy is particularly beneficial. A lawyer who has navigated the complexities of presenting a case, cross-examining witnesses, and arguing points of law is better equipped. They can understand the nuances of evidence and procedure when they sit as a judge. Section 4. Points of contention. Concerns raised by aspirants and academics. Despite the strong support from established legal bodies, the Supreme Court's ruling has not been without its critics. A significant segment of the opposition comes from fresh law graduates. Many young bright minds aspire to join the judiciary immediately after completing their legal education. For them, this 3-year practice requirement presents a substantial hurdle. They perceive it as an arbitrary barrier that delays their entry into judicial service. These aspirants often argue that their academic excellence and performance in competitive examinations should be the primary criteria for selection, not mandatory years at the bar. Section 5. Constitutional scrutiny and judicial precedents, a delicate balance. The legal challenge to the 3-year practice rule inevitably involved an interpretation of constitutional provisions. Specifically, Article 233, subsection 2 of the Constitution of India came under scrutiny. This article explicitly mandates a minimum of 7 years of legal practice for direct appointment as a district judge. However, the Constitution remains silent on the qualifications, particularly regarding prior practice, for appointment to the post of Civil Judge, Junior Division. This constitutional silence has historically led to a lack of uniformity. Different states adopted varied judicial service rules, with some requiring prior experience and others allowing fresh graduates to appear for the examinations. The Supreme Court, in its wisdom, revisited its own past observations. The 2002 case of All India Judges Association versus Union of India was a significant reference point. In that earlier judgment, the court had indeed underlined the importance of practical experience for judicial officers. Section 6. The path ahead, directives, ramifications, and future contours. Beyond the central tenet of the 3-year practice rule, the Supreme Court's judgment included several other important directives. One key mandate is the requirement for candidates to produce a certificate of practice. For lawyers practicing in trial courts, this certificate must be issued by the principal district judge. For those practicing primarily in the high courts, an advocate with at least 10 years of standing at the bar must endorse their certificate of practice. This mechanism aims to ensure the authenticity of the claimed experience. It adds a layer of verification to the eligibility criterion, making it more robust. The judgment also touched upon other aspects of judicial service. It emphasized that there should be no straitjacket formula for promotions. The evaluation for suitability in promotions should be holistic. It must include an assessment of the judge's knowledge of law and their past judgments. Annual confidential reports, or ACRs, spanning the preceding 5 years will also be considered. Furthermore, awareness of recent legal developments and effective communication skills are to be part of this comprehensive assessment. The court also noted the reservation of 10% of civil judge, senior division posts for accelerated promotions, and increased the LDC quota to 25%, aligning with earlier recommendations. A mandatory 1-year judicial training for all newly appointed judges was also directed.